Hello, and thank you for joining us for this Lawyers for Learners webinar, Arrest and Conviction Record Discrimination Laws in Wisconsin. My name is Contessa Gansky, and I'm a legal intern with Lawyers for Learners. I'm excited to present our speaker for today's webinar, Rebeca Lopez, labor, employment, and immigration attorney with Godfrey & Kahn in Milwaukee, Wisconsin. Thank you, Rebeca, for joining us today and sharing your expertise on the topic of arrest and conviction record discrimination laws. Take it away, Rebeca.
All right, thanks, Contessa. And it's nice to join you all here today and to have this important topic of arrest and conviction record discrimination laws in Wisconsin. I've been practicing employment law for the last 12 years, and arrest and conviction record law matters have come up since the beginning of my time working on these issues. So what we'd like to do today in the limited time that we have is provide you a helpful overview of what Wisconsin law requires. If we go to the next slide and then to our intro slide, we can look at our agenda. But we'll talk about background checks by the numbers, give you a little bit of context, talk about the Wisconsin Fair Employment Act, and then do an overview of recent court cases and LERC decisions. In addition, after this presentation, to help you in the work that you may be doing, we'll send you some additional materials which will help you with your own research and give you the ability to look into this issue a little bit more deeply, or to research cases if you're representing someone or advising them with regards to arrest and conviction record discrimination. So with that, let's go ahead and jump in. We do want this to be interactive, so if you have questions, please feel free to put them in the chat. I'm happy to answer them as we go along, and then if there's any where you've missed, we'll pick them up at the end of the presentation. So let's take a look at what the statistics show us. We looked at a variety of sources, and what we saw is that it is quite common for individuals to have some sort of interaction with law enforcement. In Wisconsin in 2023, one report showed that there were 115,117 arrests statewide in Wisconsin. And for context, Wisconsin has approximately 5.8 million residents. Now, when we look at how this goes nationally, however, we see that more than 78 million Americans have a criminal record. By some reports, they estimate 1 in every 3 adults has some form of a criminal history. So it's quite common for someone to have been arrested or to have been convicted in our community. Now, as you can see on this, this bottom bullet, people of color and people from low-income backgrounds are the most impacted by arrest and conviction record laws, and those laws, when they don't exist, they are very impacted as it relates to being reemployed, because statistics have found that individuals with criminal convictions or with arrest records have a harder time getting reemployed. Now, the important note here is that there's a whole body of information that's out there that talks about why the statistics are so skewed. By one estimate, Black individuals are 6 times more likely, and Latinos are 3 times more likely to be incarcerated for arrests that they have also been experienced by their white counterparts. And one of the reasons for cited for this higher impact for people of color is higher policing rates in communities of color, and a higher likelihood that individuals of color and people who are low income and in low income communities are going to be arrested. And so it doesn't necessarily mean that they're committing crimes at a higher rate. That's not the takeaway. The takeaway is just that there's a myriad of issues, including systemic racism in our systems that do lead to individuals of color being convicted at higher rates than their white counterparts. Why this is important and why we look at these statistics is that what we know and what we see if we look at the next slide is that employers at a high rate do conduct background checks. And oftentimes, if you have someone who has no results on their criminal history and someone who does, an employer may be more likely to select the individual without the criminal history for employment. As we can see, the numbers are pretty stark. 95% of U.S. employers conduct 1 or more types of employee background screening. 77% of U.S. employers have documented background screening policy, and they are the most common type of background check. And so you might ask yourself, what are other types of background checks that people conduct? They might look at educational background. They might look at licensing background, but criminal background is one that is more universally chosen. So if we go to the next slide, this is what leads us into our discussion about the Wisconsin Fair Employment Act. So we see that individuals in our society, have criminal background checks or criminal backgrounds at a rate of 1 in every 3 adults across our nation. And in Wisconsin, our legislature took a look and said, we want to balance out an interest in helping those who may have had interaction with law enforcement and may have a criminal background. We want to help them get back integrated into society. And what the study showed the legislature at that time is that if people were able to obtain gainful employment, they were able to find a job after they had served their time or completed their sentence following a conviction, they were less likely to reoffend when they're able to find employment and gainful employment. And so the legislature saw that there was a high interest in helping people get back to work and be employed and remove the stigma that's associated with arrest and conviction records. On the other hand, the legislature also recognized that employers have an interest in protecting their workplaces, and that in some instances, the risk of an individual with certain convictions reoffending could have some pretty significant consequences for the employer. And so these are the two interests that the legislature sought to balance. And where they landed is in this language here, that an employer labor organization, so a union, for example, employment agency, licensing agency, or other person may not engage in any act of employment discrimination against any individual on the basis of arrest record and conviction record. So let's go to the next slide where we get definitions for what it means for something to be an arrest record and for something to be a conviction record. For something to be an arrest record, this means that someone has been questioned, apprehended, taken into custody or detention, held for investigation, arrested, charged, indicted, or tried for a felony, misdemeanor, or other offense. So this is, they've had some interaction, maybe they were charged with an offense, but ultimately they were not convicted. That would fall within the bucket of an arrest record. Now, for conviction record, this means information indicating that an individual has been convicted of a felony, misdemeanor, or other offense, has been adjudicated delinquent, has been less than honorably discharged, or has been placed on probation, fined, imprisoned, placed on extended supervision, or paroled. And the idea here is that some sort of oversight organization, so whether it be a court, through a judge or a jury, or perhaps in the military, has gone through a process and ultimately determined that someone has engaged in the criminal conduct and therefore they have a conviction. So these are really important terms because as we go to the next slide, we'll see that the acts of employment discrimination that are prohibited are going to turn on whether something is an arrest or a conviction. So under Wisconsin's law, it is unlawful for someone to refuse to hire, employ, admit, or license an individual based on an arrest record or a conviction that is substantially related, and we'll talk about that term shortly. Similarly, to bar or terminate from employment or labor organization membership any individual based on an arrest record or a conviction, and in the case of a conviction that's not substantially related. To discriminate in promotion, compensation, or terms or conditions of employment. So paying someone less, for example, because they have a conviction record, or retaliating against them because they have engaged in protected activity, meaning that they've opposed discriminatory practice or filed a complaint, for example, with the Wisconsin Department of Workforce Development Equal Rights Division, which is the agency that is responsible for enforcing this law. Now, a very important note here. The protections that we're talking about today are under the Wisconsin Fair Employment Act. The only cause of action that is available is under state law. There is no federal law companion. So the federal, the legislature, Congress has not passed a law to give protections against discrimination based on arrest and conviction record. The EEOC has come out and stated that there is a risk of a disparate impact claim under the protections against race discrimination, for example. However, we haven't seen that really successfully litigated. So what we're talking about today are state law claims under Wisconsin law. Different municipalities in different states have different protections. All right, so if we go to the next slide, It's also unlawful to advertise discriminatory preferences. So where we've seen this come up is an employer has a job ad that's out there. They're advertising for an open role, and they say that someone must have a clean criminal record or indicate that someone can't have any criminal convictions on their record. That would be considered a discriminatory practice under the Wisconsin Fair Employment Act, because an employer can't bar from employment someone just because they have a criminal conviction. You also can't use an employment application as a tool for discrimination. So under Wisconsin's laws, we'll talk about in a moment, you cannot inquire about someone's past arrests with very limited exceptions. So it is unlawful to ask someone whether they have been arrested in the past. So not pending arrest, but a past arrest. And so if on your employment application, you ask about past arrests, that inquiry in and of itself would run afoul of the protections under Wisconsin's law. It's also unlawful to regulate any discriminatory employment policy. So if you have a policy that's only able to hire those individuals who have clean criminal histories, that policy would be problematic. So let's talk about what employers may consider. What is permissible under Wisconsin's law? On our next slide, we talk about that. And you cannot inquire about a past arrest record. So unless the person is required to be bonded pursuant to a standard fidelity bond or an equivalent bond, you can't ask about past arrest record. And the reason for this exception is that some bonding will depend on whether or not someone has even been arrested. Setting that aside, though, you can't ask about past arrest record. However, you can ask about a pending arrest. So if someone has been arrested and they've been charged in the process of going through the criminal process or going through court, that pending arrest is something that an employer can consider. And then as it relates to conviction record, an employer can inquire about someone's conviction record. You can ask if someone has pled guilty or been convicted of a felony or a misdemeanor or other similar offense. However, an employer can only consider that conviction or only take it into account to deny a promotion or deny the job to the individual if the circumstances of the conviction substantially relate to the circumstances of the particular job or licensed activity that they're going to be engaged in. And so let's talk about the substantial relationship test, because that is something that is specific, it's facts specific, and it is something that requires an analysis. The substantial relationship defense is one that an employer can assert. Even if they didn't consider it at the time of the decision, it is an after the fact defense that is raised. And what the courts look at, and we'll evaluate a case that gave us some more detail around this that was recently brought down by the Wisconsin Supreme Court, is whether or not the circumstances of the offense give an opportunity, an unreasonable opportunity for the individual to reoffend. And so a clear example of a conviction that may have a substantial relationship to the position, the specific position for which the person is applying. Example of someone who has been convicted of embezzling funds from their employer in the past, and they are then applying for a role as a CFO or account manager for a new employer. The conviction, the circumstances of the conviction, the prior conviction, were that this individual, took this position of trust and they misappropriated funds. And in the role of a CFO or an account manager, where they have responsibility for purchasing or over accounts and checks and financial institution relationships of the business, there's a higher likelihood of potential to reoffend. And so that's a clear example of a substantial relationship. An example of something that is a very difficult and may be impossible substantial relationship to establish is the example of someone who might have been convicted of inappropriate contact with a minor, where they are working in a position at a manufacturing facility where there are no minors present, no minors employed, and they are under constant and strict supervision. Even though for some employers, someone with that type of a conviction might be viewed as someone that they don't want to hire, it would be very difficult, more for them to establish a substantial relationship unless there are additional facts that increase the likelihood of recidivism. So let's talk about this unacceptable level of opportunity for the employee to reoffend in the workplace. Again, this is an employer's burden to establish. It's fact specific and it's not defined in the law. It's defined through case law. And what we have to look at are the specific elements of the conviction. So we look at the actual offense for which they were convicted. We'd go to the Wisconsin statutes and we would look at the criminal conviction statutes and we would evaluate what the elements of that offense are. And then we would look specifically at the job duties and responsibilities that the applicant would hold, or if it's a current employee, what this new position would be for them. And that's when we undergo and conduct the analysis. So as a management side attorney, I'm working with my clients to determine whether there is a higher risk of recidivism for this individual if they were going to be placed into this position. Now, there's another potential defense for employers. On the next slide, we talk about the Onalaska defense. And this defense is only available when it is in reference to an arrest record. And so while arrest records themselves generally cannot be used, employers are permitted to perform an independent investigation of circumstances surrounding an individual's conduct. And if through that investigation, the employer is confident that the individual actually did commit the misconduct, they can lawfully terminate or refuse to hire the individual. The decision to do so must be based only on what was uncovered in that employer's investigation, not on the individual's arrest record itself. So in the case that this defense is named for, so it related to the Onalaska Police Department. The Onalaska Police Department hired a trainee whose brother-in-law was arrested for speeding. At that time, the brother-in-law referenced two police officers that he was racing. And in response to a question by the officer, the trainee said he supposed he was the person that his brother-in-law was racing. So essentially they were engaged in unlawful street racing at the time. The trainee resigned after the chief said he could either resign or be fired, and he was subsequently then charged with racing and found not guilty. The city said that they would not have fired the trainee absent the racing incident. And the court held that if the employer discharged the trainee because it concluded from its own investigation and questioning that the trainee committed the offense, the employer was not relying on an arrest record, but rather on their own investigation. Now, this is a really difficult defense to establish, but it is a helpful one if you're representing an employer. And likewise, if you're representing an applicant or an employee, it's important for them to know that if they're providing information pursuant to an investigation, that information may potentially be relied upon by an employer in making a decision about their employment. All right, another exception is on the next page, and we alluded to this a little bit earlier, but this is with regards to pending criminal charges. And if the individual has pending criminal charges, and those pending criminal charges substantially relate to the position, so this is the same analysis we were talking about earlier, employers have options depending on what stage they're in. So if it is an applicant for employment who has applied for a job and they disclose that they are subject to a pending charge, and again, employers can ask about pending charges, just not past charges or past arrests, and that pending charge is substantially related to the position they're applying for, the employer may lawfully refuse to hire that individual. As it relates to current employees, however, an employer is not permitted to terminate them based solely on if the pending charge is substantially related to the position that they hold, the employer can then suspend the individual pending the outcome. If they are then convicted and that conviction is substantially related to their position, at that point they would be able to end employment. However, if they're not convicted, so they're found not guilty, or they reach some sort of a plea deal and the conviction for which they plead is different and not substantially related to the position, then the employer may need to reemploy that individual. And so that analysis, that substantial relationship analysis, would have to be conducted anew by the employer once the conviction is entered. There's a couple more exceptions on the next page that we won't go into too much detail on, but just be aware that if someone has a conviction record and that impacts their ability to be bondable, and that bondability is an important part of the position. We've got some examples here of positions that require a bond, and they were convicted of a felony, for example, and not pardoned for that felony. That can prevent them from holding these bondable positions. Likewise, if they are denied a license and that license is required for them to hold the job, then the employer may lawfully determine that they cannot employ the individual based on the fact that they don't have the necessary license. But in that case, you're not basing it on the individual's conviction record, rather you're basing it on the individual's holding of the license. All right, so a couple of employers' actions on the next stage that can help you evaluate are permissible and not permissible. So we've included these here. We've talked about them already in the prior slides, but we thought that this information in this summary might be a helpful reference guide to you. All right, on to the next slide. It's important to know that if someone believes that they've been subject to discrimination based on arrest or conviction record, there's a 300-day statute of limitations. Under the Wisconsin Fair Employment Act, the remedies that are available if they are successful in bringing such a claim are back pay, interest, reinstatement, and attorney's fees. Under Wisconsin law, there is no avenue to obtain punitive damages or compensatory damages. So it's important to be aware of that. All right. So with the time that we have left, what I thought would be really helpful is for us to talk about a couple of recent cases that have come down from the Supreme Court and the lower courts. The next slide talks about one of the most significant, I would argue, arrest and conviction record cases to come down in the last decade. And that case is called Cree versus Lurk. Cree at the time was a manufacturer and marketer of lighting components, and they had someone apply for a job with them as an application specialist. And Cree offered the position contingent on a successful background check. The position involved traveling to customers' facilities for consultation, working collaboratively with customers and coworkers, and occasionally traveling with overnight hotel stays, potentially with coworkers as when that traveling took place. It also involved a significant amount of independent judgment without direct supervision in large facilities with areas that lacked security cameras. So they conduct the background check on the applicant, and what is revealed is that the applicant had been convicted 2 years earlier of 8 violent crimes against a woman he was dating, and they included convictions for sexual assault, felony strangulation and suffocation, misdemeanor battery, and criminal damage to property. As a result of that background check, the company rescinded the offer and then argued that there was a substantial relationship between the job and this individual's conviction record. The Supreme Court ultimately held that the convictions were substantially related, and they articulated an updated analysis to be used when conducting the substantial relationship test. What they argued was that the relevant inquiry is whether the circumstances of the position would present opportunities for the individual to reoffend in the workplace. Here, they said the violent nature of the applicant's crimes showed a propensity for exerting control and dominance, which made him ill-suited to work with others, especially given the important role of interpersonal relationships, both with customers and with coworkers. They also highlighted the fact that this individual had had very little supervision in areas where there weren't security cameras, and as a result, that could give rise to an opportunity to reoffend. And they cited the frequent overnight travel obligations as additional risks. The court clarified the following factors that should be considered. So the character traits that are revealed by the conviction, the seriousness of the offenses, the number of the offenses, how recent the conviction was, and whether the background check conveyed a pattern of behavior. So one of the arguments that was made was that this incident by this applicant occurred with someone in a romantic relationship. And for years, there had been arguments that employers shouldn't be able to consider those in the workplace because the personal relationships weren't likely to present themselves in the workplace. The Supreme Court shot that down. And so there is wider latitude to be able to consider convictions that may be related to domestic violence than there had been previously. I think one thing that can be challenging is the new language around how recent the offense was. Previously, the courts did not consider how long ago the offense took place. They only elements of the offense in the job, but now that's a factor that is being considered in some cases, as well as how often this individual has reoffended or the seriousness of the offense. On the next slide, we have some additional clarification provided to us by a case with regards to the Onalaska investigations. In this case, Vega v. Lurk, an employee with 2 deferred prosecution agreements for felony sexual assault was interviewed by their employer. In the conversations, the employee admitted to engaging in the behavior. And as a result, the employer argued that they had conducted their own investigation and based solely on the employee's comments had made the determination that the employee had engaged in the complaint of behavior. The court said that the employer could use the Onalaska investigation defense because the deferred judgments had not been adjudicated as a conviction and therefore they were still arrests. So even though there were these deferred judgments that were negotiated with the court because the conviction had not formally been entered, it still qualified as a arrest and therefore subject to the Onalaska defense. However, an important note in this case, the individual did have past convictions, and the employer agreed and acknowledged that they based their decision to terminate employment both on their Onalaska investigation as well as the conviction record. And the court held that the convictions did not qualify as substantially related. So the reliance in part on those convictions was violated. But because it was a mixed motive case, in the case of a mixed motive case where there's a permissible and non-permissible, and both of those equally factored into the decision-making by the employer, the remedies available to the complainant are only the attorney's fees and costs. So that is all that the individual was able to recover. They were not entitled to reinstatement or back pay. On the next slide, I won't go into too much detail about this, but this involved the Oconomowoc School District that terminated 2 employees based on their belief that they stole and sold school scrap metal. They were cited with municipal violations, and what the court determined is that those municipal violations are not arrest records and also don't fall within conviction records. So as a result of that, municipal citations they held are not criminal violations, and therefore the employer could lawfully them. This case is on appeal to the Wisconsin Supreme Court, so we're holding tight to see if that holding continues, but at least for now, there is some case law that supports this proposition. On to our next case, Lane v. Bellin Memorial Hospital. Incident where we see the Cree decision playing out. This involved a physician who specialized in pediatric care who had pending charges for obstructing an officer, battery, criminal damage to property, domestic abuse, and disorderly conduct, all arising out of a single incident. And interestingly enough, LIRC determined, the Labor and Industry Review Commission held that because the charges were only related to a single incident, there wasn't a pattern of violence or criminal activity. And said as a result of this, the individual who had worked for the hospital for 17 years without incident, there was a low likelihood that they would become aggressive with a patient's family member, or a coworker. They said that as a result of that, there wasn't a substantial relationship. So we see in this case where that Cree decision is playing out in LERC, and the Labor and Industry Review Commission is looking skeptically at determinations of substantial relationship where there might only be a single incident on someone's record. All right, and then for the last case that we're going to evaluate today, this one goes in the other direction. And in this case, MATC suspended the complainant while charges of embezzlement were pending. In that complainant's role, he was required to place orders for tools and supplies to be used in teaching his classes, and would receive the orders and often taught offsite with tools from campus. In this case, LERC went in the other direction and determined there was a substantial relationship between the pending charges and this individual's role. And what they said is that there was a greater than usual opportunity to reoffend because of the lack of supervision and the autonomy that the individual had in making orders and having oversight of these supplies. An important note here is that LERC noted that no particular motive for the complainant to reoffend need to be identified, only that the circumstances of the job put the complainant at an increased risk of recidivism. And so you're seeing a number of different cases coming out of LERC. One of the resources that I've provided for you is the link to the Labor and Industry Review Commission's website. If an individual files a complaint, that complaint first gets investigated by an investigator, and then it may go to an administrative law judge for a hearing on the merits or on probable cause. And if someone is successful, they have the opportunity to appeal to the Labor and Industry Review Commission. So that is the appeal body. And only if they disagree then with the decision of LERC can a case be brought in court, but that case is brought against LERC, not against, for example, the individual complainant or respondent. And so the LERC case law is important to be familiar with, in addition to state law cases up through the Supreme Court, because those are going to be the cases that you would rely upon for making your arguments and establishing your defenses. I really appreciate you joining us here today and hope you found this presentation to be helpful to you in the work that you're doing.